I want to continue this conversation right now on the breaking news. Joining us, the former federal prosecutor Elise Adamson and Seth Berenzweig, a white-collar defense lawyer and constitutional attorney. Elise, what did you make of the defense's case now that they have rested?
Well, I think the defense made the right choice by not calling Hunter Biden, right? A defendant has a constitutional right not to testify, and most of the time they don't. I think the defense did a good job knowing when to stop. We've seen recent examples when they didn't, and in other cases. But here, Naomi Biden provided testimony on Friday that she didn't see her dad using drugs during that critical time period in October, and that she had been proud of him. Now, the prosecution did cast some doubt on that account by then confronting her with text messages from Hunter where he was apologizing for not being present, but I think her testimony was strong enough to rest on, and so I think with the strategy, which is just reasonable doubt, the defense ended as strongly as they possibly could.
And the defendant has a right to testify and not to testify in these kinds of criminal cases. What are the pros and cons? Most lawyers tell their defendant, don't testify.
That's absolutely right. I spent a lot of time as a prosecutor. I'm now a white-collar criminal defense attorney, and I would always advise my clients, unless in the most rare occasions, not to testify, right? Because the defendant has a constitutional right not to. It is the government's burden to prove the case beyond a reasonable doubt. Once the defendant is on the stand, who knows what's going to happen? Of course, they will tell their story, but then it opens the door for the prosecution to cross-examine them. And then the jury can consider what they've heard the defendant say. They could find them not credible. Whereas if it is just the prosecution's case and the defendant does not testify, then the burden is where it should be, which is on the prosecution. It's just too risky to have a defendant testify because you don't know what the prosecution is going to ask them.
Let me ask you this. If you were representing Hunter Biden, Seth, would you advise him to testify and tell his side of the story, or just remain silent?
I would tell him to remain silent. I concur. I think that it was too risky to put him on the stand. Abby Lowell has been around the block on this many times. Yes, and I'm not surprised by that decision. I think it was the right decision, and I think it's very telling to see who's testifying right now. I'm a little bit surprised that the prosecution's putting on a rebuttal witness. This is the special agent that testified earlier in the trial, and this person is being brought back on the stand to tie up loose ends with regard to what happened just a couple of days after Hunter Biden signed that form, question 11, whether he knowingly misrepresented whether he was a user or an addict. And interestingly, the facts of that show that within a couple of days of when he signed the form, he texted his then girlfriend that he was going to meet Mookie, who was a dealer, to go ahead and get more drugs. Achilles was only as strong as his heel, and the Achilles heel in this case are the mountains of evidence, which is really just including a lot of piles of dirty laundry showing that he used shortly before and shortly after the form. So that's the reason for the rebuttal witness, and then we're going to get into closing arguments.
Because it seems like the prosecution in this case has a pretty strong case right now.
Absolutely. To Seth's point, they do have a mountain of evidence. They have, I believe they put on a forensic chemist to testify that there was some residue found on the gun pouch to prove that there was some contemporaneous drug use with the possession of the weapon. We have Hunter Biden's own words taken from his memoir, which I believe was very strong for the jury. And quite frankly, the defense tried the best that they could, but they weren't really able to bring a lot out to cast doubt. It is all about, did Hunter Biden know that he was an addict? Did he consider himself an addict during those 11 days and at the time he signed those forms? And there was no direct evidence, but there sure was a lot of circumstantial evidence. So if I was the prosecution, I'd be feeling pretty good going into closing arguments.
Hunter Biden's defense lawyers, including Abby Lowell, who's well known here in Washington, called only 3 witnesses on Friday. They did not have any more witnesses to testify today. What does that suggest to you?
Well, it didn't surprise me. I didn't think that they really had a lot of evidence to affirmatively put on. His daughter provided some very emotional testimony. She was subject to a pretty aggressive direct examination. I think that the defense overall has done a good job insofar as they have tried to keep the car right in the middle of the road, and they've been very, very specific. But even if that evidence, and I agree with you, I think the evidence is pretty overwhelming, even if that evidence gets them to, say, the 1-yard line, the only way that he's going to get, the defense counsel is going to get the ball into the goal line is if they pull out the heartstrings of the jury. This has to be a very emotionally pulling closing. They have to humanize and sympathize Hunter Biden, and that's going to be, I predict, a really big part of the closing argument of the defense in this case.
I'm sure that's one of the reasons the First Lady has been sitting there during this course of this trial to show her support for her son.
Absolutely. She's been there, I believe, every day. She flew back from France to be there for him. And I think the jury sees that. I think it's also important to note that I think it's something like 8 out of the 12 jurors have been personally affected by addiction, either in their family or themselves. And so they're going to be bringing that experience to their deliberations and when they are listening to the summations. That said, they're going to be instructed by the judge that they need to focus on the evidence in this case. Though I agree with Seth that the feelings that the defense is going to evoke during the closing arguments is important, but then they're going to be told that they have to focus on the evidence, apply the facts to the law, and I think the government has proved their case.
If he's convicted on all 3 counts that he's charged with right now, potentially he could face up to, 25 years in prison. Is that realistic at all?
No, he's not going to face 25 years in prison. Under the sentencing guidelines, he could face no prison time at all, or maybe incarceration during the weekends. The other thing to point out as well is that any kind of a sentence will be stayed pending appeal. There are some appeal issues here, and I know it's a little bit premature to talk about that because we don't have a jury verdict, although we'll probably have one in a couple of days. You have a very interesting recent decision out of the Fifth Circuit Court of Appeals stating that this kind of a prosecution essentially constitutes unlawful discrimination based upon prior drug use because people can't have their right to gun ownership inhibited by prior use. And there could be an argument that, and this defense has said, during these 11 days, no one saw him use drugs. And what they're asking the jury to do is to infer and essentially collapse that down into the window of time because of his prior drug use. So you have an issue on the law, you're going to have an issue with respect to the judge barring expert witness testimony with regard to his state of mind. So it's going to be a close call. But if there is a prosecution, if there is a conviction, stand by for appeal.
Yeah, and a lot of lawyers have said to me that they think he should have pled guilty in exchange for a reduced sentence recommendation from the prosecution. You think that would have been wise?
That's very hard to say. It's hard to say what was in the mind of the defense or of Mr. Biden himself. When you plead guilty, you give up your appellate rights. And to Seth's point, there are some real questions about the constitutionality of this particular statute. So it could be that it was a Hail Mary decision. We'll go to trial. You know, the best case scenario, we get an acquittal. The worst case scenario, it goes up on appeal. A lot of times we do, as defense attorney, recommend taking a plea when the evidence is as strong as it is here, because that is taken into account during sentencing, and because he is eligible for probation, it might have put him in a better position. But it's really tough, especially with where the statute stands legally.
Elise and Seth, to both of you, good discussion. Thank you very, very much. We'll stay on top of this story.